Diana. Claimant is in court, my lord. Defendant absent.
Claimant present.
Yes, ma'am.
Appearances. Appearances. No
May I please,
counsel
Honorable Court?
online.
May I please, Honorable Court?
Yes.
Go
ahead.
Yeah, when most humbly I make appearance for the
I
claimant.
can hear you.
Most humbly, Your Lordship, CM Uche
The
Nwene.
name again.
CM Uche Nwene.
PM.
No, C, Your Lordship. Chibueze Moses Uche Nwene.
No problem. I've gotten it. I've gotten your C. Uche Nwere.
Yes, Your Lordship. For the claimant. For the claimant.
Any other appearance? Yes. Any other appearance? Any appearance for the defendant? Any appearance for the defendant? Court registrar, did you inform the defendant?
My lord, I saw the defendant, the first defendant counsel online. I don't know.
Where is he now? I can't see him online. Who is the first defendant counsel that you saw online? If you are representing any of the defendants, please identify yourself and talk to the court. Any appearance for the defendant? Court registrar, you said you saw the first defendant online. I can't see. Who is using P10 something? Court registrar.
Hello, she seemed not to be there. No.
You said she was online.
Yes, I saw her online, but she seemed not to be there. No.
Who is using Infinix? Is that Bridget?
My lord, it seems she's no longer.
And did you send hearing notices to them?
Yes,
did you send hearing notices to the defendants? You have
yes,
proof of service. Very well. So I'll go ahead. Now for the defendant. Who is using 2029? Is that the Defense Council V2029 trying to connect? Any appearance for the defendants in this case?
May it please the court.
I can see someone with V2029 phone or tablets. Are you representing the defendant?
Yes, my lord.
Mm-hmm.
The first defendant, my lord.
Go ahead.
May it please, my lord.
This name.
I'm G.O. Zachary, Mrs. My appearance is for the first defendant.
This name. Mm-hmm. What's the name?
G.O. Zachary.
Any other appearance? Any appearance for the second defendant? Sorry, for the second defendant. Kneel for the second defendant. Go ahead and read the decision of his, so the second defendant may obtain it. By general form of complaint, and found it. Sorry, my internet had a little issue. I hope you can now hear me and see me.
Yes, my lord.
Very well. By general form of complaint, dated and filed on 18th September 2019, the claimant claims jointly and severally against the defendants as follows. 1, a declaration that the claimant was unlawfully dismissed from the employment of the first defendant. 2, the claimant claims against the first defendant the sum of 249,750 naira, representing all unpaid severance allowances from 24th January up until the initiation of the suit. 3, a declaration that the claimant is entitled to unpaid severance salaries upon dismissal from the service of the first defendant. 4, an order that the claimant is entitled to unpaid severance salaries upon dismissal from the services of the first defendant. 5, a declaration that the claimant is entitled to gratuity and compensation for injury suffered upon his untimely dismissal without notice of same to him. 7, an order that the claimant is entitled to gratuity and compensation for injuries suffered. 7, the claimant further claims that the first defendant 10% interest per annum until the sum claimant is claimed is fully and finally liquidated, and is claiming 3.3 million naira being cost of unpaid severance salaries and compensation. A declaration that the claimant was unlawfully dismissed from the employment of the first defendant, and he listed the particulars of his claim, whereof he is claiming against the first defendant the sum of 3,371,250 naira as special damages and allowances of 2 million naira as general damages for unlawful dismissal as per release 1 to 9. And the alternative is claiming against the first and second defendant jointly and severally the sum of 3,371,250 being severance, salaries, compensation, injuries suffered at the place of work. The particulars of special damages against the defendants are as listed in the reliefs in this judgment, as captured in this judgment. It is the case of the claimants that he was an employee of the defendant as a carpenter in iron scaffolding, that during evacuation of the scaffolding being the normal course of his duty, in the first defendant, he had an injury when the clip hit his leg, as a result of which he suffered a fracture on his right leg. Now, prior to his dismissal, his salary was at 1,350 naira. However, half his salary was offered to him for the period of injury, Going further, he stated that in the alternative, he asked for the reinstatement into the company with the option to perform a less hectic work due to the fact that he was still recuperating from the incident, that his compensation for injuries suffered and other entitlements inclusive of benefits were not paid, but rather he was placed in a department as hectic as the former. Continuing, he stated that he kept appealing to the first defendant to allow him have a complete pay of all unpaid severance salaries, but the first defendant refused, which led to his dismissal without notice of payment of salary in lieu of notice. On the 28th of April 2022, he opens his case, testified for himself as CW. He tendered Exhibit 01 to 04. He was cross-examined by counsel on behalf of the second defendant, after which he closed his case. On the 26th of July, a date fixed for the defense to enter into their defense, the defendants failed to open their case, and they equally failed to file defense to this suit or enter formal appearance. Thus, their case was foreclosed, and the claimant was asked, in compliance with the rules of this court, to file its final address, wherein the matter was adjourned for adoption. However, the second defendant, by a notice dated 28th of July, filed on 29th of July, sought for an order of court setting aside the ruling dated 26th of July 2022. He was moved and argued, and same were his views and discountenance by the court on the 10th of October 2022. The application of the first defendant for extension of time and regularization of processes equally suffered the same fate for the more elaborate reasons given in the rulings of this court delivered on the 11th of October 2022. The first defendant filed a notice of preliminary objection dated 26th of September 2022, seeking for the striking out of this case against the first defendant. The grounds upon which this application was filed are that the name Sinoma International Engineering Company Limited is not the name of the first defendant, that the first defendant name was Sinoma Nanjing Construction Nigeria Limited, which was changed to NGZC International Construction Nigeria Limited since 26th of March 2015. B, the first defendant was wrongly served with the process of the Honorable Court with the name Sinoma International Engineering Company Limited. C, the head office of the first defendant situated at 9A Adenubi Close off Toyin Street, Ikeja. D, the suit is incompetent as it does not disclose any employer-employee relationship between the claimant and the first defendant. Also filed as a written address wherein counsel framed 3 issues for the consideration of the court. I've reduced all that into the body of the judgment. In opposition, the claimant also filed a counter affidavit and written address. I've equally reduced that into the body of this judgment. The first defendant equally filed a further and better affidavit and reply on point of law to the claimant counter affidavit. Have reduced that into the body of the judgment. As it is customary to do at the close of evidence and in observance with the rules of the court, the claimant, who was the only one who called evidence and the only one who filed his written address, adopted same. And I've also reduced that into the body of this judgment. Now I will go straight to the decision of the court. Let me start by addressing the competence of the application for stay of proceeding filed by the first defendant on the 9th of November 2022 after this matter has been adjourned for judgment. It is well settled that a court is duty bound to consider all applications properly brought before it. See the case of Keke and Weichina, citation captured. However, it should be noted that the operative word is quote and unquote properly brought before it. In this instant case, this court on the 13th of October 2022 adjourned this matter for judgment On the 14th of October 2022, the first defendant filed a notice of appeal in this court. It did not file any other process until the 9th of November 2022, when it filed its application for stay of proceedings pending appeal, knowing fully well that this matter has been adjourned for judgment. The question that should be asked at this stage is, was the application for stay of proceedings properly brought before this court? In answering this question, I will refer to the decision of the Apex Court. In the case of Okeke and Owechina Supra, at page 192, paragraph C to F, where the court held inter alia that each case must be treated and considered on its own particular peculiar facts and circumstances, as no two cases are identical or the same, though they may be similar. The court went further that even though cases cited by the appellant represented a position of the courts with regards to the settled principle of law, that all applications properly brought before a court must be heard, they were not apposite to the appeal because there was an instant order which have not been discharged, was binding on the parties as well as on the Court of Appeal. In the instant case, the National Industrial Court Civil Procedure Rules 2017 specifically provides by its order 47, rules 14 and 19 does, and I quote, where a matter is fixed for judgment or ruling, no motion shall be allowed to prevent a judge from delivering the judgment, order, or ruling. 15.1, any motion filed in contravention of Rule 14 of this order may be incompetent and may not be allowed to be used to delay or prevent the delivery of judgment, order, or ruling of the court. 2, a motion or an application which has been filed and an advanced copy of same has been served on the respondent within 14 days before the date fixed for the delivery of the judgment and 7 days before the date fixed for the delivery of ruling may be allowed and held, unquote. It is clear from the above that the rules of this court generally does not allow any motion to be filed when a case is filed for judgment, having the effect of preventing the judgment from being delivered, and thus any such motion filed will be incompetent. However, the rules equally gives the court the discretion to allow any such motion where it is filed within 14 days before the date of the delivery of judgment. The operative word in order 47, rule 15.2 is quote and unquote may, which allows for discretion. Thus, even where the motion is filed within 14 days before the delivery of judgment, the court still has a discretion whether or not same is competent or not. In the instant case, the defendants have tried severally to frustrate the hearing of this case, which has been filed since the year 2019. The court will not allow a party to hold it to ransom at its own whims and caprices. It is in the light of the peculiar facts and circumstances of this case that this court finds that this situation is not one that merits exercising its discretion in its favor. It is in the light of the above that this court finds that the application for stay of proceeding is not competent for hearing. It is consequently discountenanced. Be that as it may, first defendant in this case, after the court has foreclosed it and discountenance his application to set aside the ruling of this court for closing it and deem its processes filed as properly filed and served, filed a notice of preliminary objection challenging the jurisdiction of this court. Consequently, the matter was adjourned for hearing of the notice of preliminary objection. On the date fixed for hearing of the notice of preliminary objection, the court, however, bore in mind that learned counsel for the first defendant was not properly before the court since the motion for regularization of the first defendant process, including the memorandum of appearance, has been found to be without merit and the process discountenanced. The notice of preliminary objection was therefore incompetent on the authority of Eshiet and F. Young and others citation captured. Thus, the court decided not to hear the notice of preliminary objection since the first defendant is not properly before the court in view of its failure to file a memorandum of appearance, and the court adjourned the matter for judgment since, failure to file a memorandum of appearance and adjourn the matter for judgment since hearing has already been concluded and claimant has adopted his final written address. Now, let us assume that the notice of preliminary objection is even competent. Can it be said that this court does not have jurisdiction to entertain this case? The applicant's counsel had submitted that the first defendant name is NJZC International Construction Nigeria Limited, previously known as Sinoma Nanjing Construction Nigeria Limited. And that being a corporate body, it ought to be served in line with the provisions of the rules of the court, noting that service of the originating process on a party to a proceeding is fundamental and imperative step of adjudication that ignites or gives the court jurisdiction to entertain the matter and make order that will be valid and subsisting. The claimant respondent argued in the opposite direction as he proceeded that in determining whether a court has jurisdiction over a subject matter, it is the writ of summons and statement of claim that the court will look at, and that the first defendant change of name does not in any form bar the claimant from instituting an action, as the claimant can only act upon the name supplied to him in the course of employment. Jurisdiction of the court is the lifeblood and bedrock of all trials, without which the trial will amount to a nullity. It is the lifeblood on which all trials thrive. See the cases of Odom and PDP citation captured. The law is tried that it is only a juristic personality, either a natural or artificial person created by law, that has a right to sue and be sued. It is the position of the law that when a person has been sued under a wrong name, the originating process can be amended by joining that party in its correct name, especially where the parties are not in doubt not to have been misled as to the identity of a person to be sued. See the case of Registered Trustees of Airline Operators of Nigeria versus NAMA, citation captured. In the instant case, a careful look at the documents front-loaded with the complaint, particularly the identity card, leaves no doubt as to the identity of the person sought to be sued. Rather, it is the coinage of the name of the said applicant that was not properly done. In the case of Calabar Municipal Government on honesty, citation captured, the Apex Court held those, I quote, misnomer occurs where the appropriate party is brought to court, but the process reflects a wrong name of the appropriate party. Misnomer can be said to be a mistake in name that is given an incorrect name to a person in the writ of summons. It occurs when a mistake is made as to the name of the person who sues or is sued, or when action is brought by or against the wrong name of a person. A misnomer occurs when the correct person is brought to court, but is in a wrong name. A misnomer occurs where a person clothed with juristic personality sues or is sued. Well, there is a mistake in stating the correct name of the party, unquote. See also the case of UUV versus Sophia, UUV Sophia versus UV Union, citation captured. The question that should be asked at this stage is, can one say the name of the first defendant is a misnomer, which does not affect the status of the parties? And next, as Exhibit A to the affidavit in support of the notice of preliminary objection, at page 190 of the record is the certificate of incorporation of one NJC International Construction Nigeria Limited, previously called Sinoma Nanjing Construction Nigeria Limited, by that certificate, and the fact deposed to in the affidavit in support of the notice of preliminary objection. It is not in doubt that the first defendant, though not known as NJC International Construction Nigeria Limited, is a juristic person. The only issue then seems to be that it was sued in a wrong name. To my mind, following the decision of the courts, such is a misnomer which is not fatal to the claimant case, I so hold. With regards to the service of the originating process, the party wherein the first defendant contended that it was not done in line with the provision of the rules of the sport, it is tried that service of court process is a sine qua non to jurisdiction. See the case of Akande and Jegede, citation provided, Ezim and Menakaya, citation provided, Akugo and Limited versus OHMB, citation also captured. The claimant in response submitted that there are evidences indicating proper service on the defendant applicant. The law stands firm that what regulates the service of court process is the rules of court at both federal and state levels. See Agib Nigeria Limited and Agib Petroleum International. Citation provided. The rules of this court specifically guides this court as regards service of processes. By Order 7 Rule 1H, it provides for what will be proper service where person to be served is a company. And I quote, if the person is a company or the other body corporate, by serving a copy of the document or process on the senior or a responsible employee of the company or body corporate at its registered office or at its principal place of business within the federation or its main place of business within the judicial division in which the dispute first arose, or if there is no employee willing to accept service, by affixing a copy of the document or process to the main door or place of business or by posting same on the wall or on the fence of the residence or place of business, unquote. The above provision of the rules of this court is very clear and is to the effect that a company may be served through a senior or responsible employee of the company at its registered office or at its principal place of business within the judicial division in which the dispute first arose, or by pasting the process to the main door place of business. It is therefore clear as crystal that service may be offered on a company at its place of business other than its registered office. I am mindful of the submission of learned counsel for the first defendant by paragraph 5.0 of the address in support of the notice of preliminary objection at page 8 of the process, that it was the security men of the second defendant that were served, who are not employees of the first defendant. First, such question of fact ought to be deposed in the affidavit and not in the written address. The above fact was never deposed to in the affidavit in support of the notice of preliminary objection. It is settled that what guides the court is the record of the court. See the case of Danladi and Dangeri, citation captured. In fact, the Supreme Court in the case of Ngubuya and Ikebunum, citation captured, held that where in proceeding, the question arises whether or not a process of court has been served in the proceeding. It will be a strange thing for a court to ignore the proof of service afforded by its record of proceeding and hold that such process has not been served. See also the case of AG Anambra and Ukeke, citation captured. From the records of this court, particularly the affidavit of service at page 31 of the record, it is clear that the bailiff of this court, in person of one Ali Abubakar Alaji, on the 4th of October 2019 at about 11:25 a.m., served one Peter Sinoma Administrator Translator at Sinoma International Engineering Company Limited within Dangote Cement Factory, Obajana, Kogi State. It is worthy of note that claimant by paragraph 2 of his statement of fact has averred that the first defendant is an agent of the second defendant, Dangote Cement Company, and works for the second defendant in the cement factory. In fact, paragraph 3G of the affidavit in support of the notice of preliminary objection specifically states, and I quote, the principal officers of the first defendant are all at the head office, while few of his staff are in Obajana, Kogi State to complete contract for the second defendant, unquote. It is thus not just sheer coincidence that one Peter, who is designated the administrative translator of the first defendant, was served at the premise of the second defendant in Obajana, which to me will qualify as the place of business of the first defendant within the judicial division of this court, that is Kogi State, where the dispute in this case arose. The first defendant in this case have not stated that it has no employee at Obajana at all, which will have meant that the person served at Obajana was not its employee. It merely stated, read paragraph 3H of the affidavit does, I quote, that the process of this court were not served on any of the staff of the first defendant directly and was not brought to their knowledge, unquote, which this court finds to be untrue, going by the content of the affidavit of service sworn to by the belief of this court, stating that one Peter, the administrative translator of the first defendant, was served. The question that agitates my mind is if the first defendant were not served as proceeded, how were they able to know that the case was in court? It is not compulsory under the rules of this court for the first defendant to be served at its registered office or address. The mode of service adopted to me is proper service. I so find and hold. On the third ground of the objection, it is the contention of the first defendant that claimant's suit has not disclosed any employer-employee relationship and as such, incompetent. Then counsel for the first defendant submitted in his recent written address in support of a notice of preliminary objection that claimant has not disclosed that he is an employee of the first defendant, that the onus is on him to prove his employment. Let me say that the import of the above objection is that claimant has not shown a cause of action or reasonable cause of action against the defendant. The law is right that the effect of failure to disclose reasonable cause of action is that the claimant has no legal standing. See the case of Wazori and Governor of Imo State, case of Shendemi and Governor of Lagos State, citation provided. The reasonable cause of action is a cause of action with some chances of success when only the allegation in the plaintiff's statement of claim are considered. Thus, the law is on the firmer terrain that when the claimant files an action and the court is faced with deciding whether there is a cause of action, what the court considers the statement of claim and the accompanying processes. See Kenya Local Government and WAPC Limited, citation captured. Hence, the weakness of the case or that it is not likely to succeed is not to be considered at this preliminary stage. Thus, for a statement of claim or facts to disclose reasonable cause of action, it must set out the legal rights of the plaintiff and the obligations of the defendant. It must then go on to set out the facts constituting the infraction of the claimant's legal right or failure of the defendant to fulfill its obligation. In the instant case, claimant by paragraphs of his statement of facts averred that he was an employee of the statement of the defendant. He was an employee of the first defendant and stated further that he worked as a carpenter in iron scaffolding at the Obajana business place of the first defendant. See paragraphs 1 and 5 of the statement of fact. Also frontdated as part of the list of exhibit is the photocopy of his ID card in the name of the first defendant. He equally stated that he had injuries while working for the defendant, which resulted in a medical attention for which the first defendant paid for his medical bills with an assurance to pay his salary, unpaid salaries. He also averred that during his service with the first defendant made little or no provision for adequate protection against hazard, which are likely to ensure from his job description inclusive of hazard allowances, and he was exposed to working under high conditions, which resulted in injuries suffered prior to his dismissal. Hence, his claim for general damages. In my view, the above facts are sufficient enough and had disclosed a reasonable cause of action against the first defendant. Flowing from the above, I find the first defendant applicant's application to be unmeritorious and consequently discountenanced. Before going into the merit of this case, it is important to note that the second defendant in this case took part in the entire trial of this case. The second defendant counsel actually cross-examined the claimant and has been representing the second defendant has been represented in this case right from the commencement of this action. And on the 18th of March, 2021, the second defense counsel was present in court, even though he did not file any memorandum of appearance. However, for reasons best known to it, despite being represented by counsel right from the sitting of this cause, or the third sitting in this case, chose not to file its pleadings until after both defendants were foreclosed by the court after several opportunities. Pursuant to the above, this court found no merit in the second defendant's application to set aside the ruling of the court for closing it, as I've stated earlier in this judgment. The law is settled that a defendant who failed to file a statement of defense is entitled to a hearing before the court, even though he cannot lead evidence. The only legal effect in that circumstance is that the defendant is deemed to have forfeited his right to first address the court. However, he can, for example, rely on a point of law arising from the statement of claim without the necessity of filing pleadings and adducing evidence. He may rest his case on the claimant's case and simply wished to address the court on the issues raised in the claimant's case. See the case of Maje Kodrumi and others, Zubunsheye, citation captured, Main Street Bank versus Yao, citation provided. However, the second defendant in this case did not equally exercise its right to address the court on any point of law raised in the claimant's claim, despite being aware of the order of court for parties to file their final addresses, even when it fully partook in this case. It is settled that fair hearing is not hearing at all costs, but fair hearing within reasonable time. It is in the light of the above that I will proceed to consider the merit of this case. The sole issue appropriate for the determination of the case at hand is whether claimant by the evidence of record has proven his case to be entitled to relief sought. It is pertinent to state at this stage that there is no pleadings of the other parties as I've stated. This is because it is tried law that the effect of failure of a defendant to file pleadings is that the assertion of a claimant in his pleadings stand unchallenged and are deemed admitted and established. See the case of Bauchi State Government and Gumai and another. However, this court is mindful of the nature of the case at hand. It is a well-settled position of our law that there is no onus to prove what has already been admitted. See the case of Aliyu Balogun and Shitu Labiru. However, it should be noted that this is a declaratory action wherein complainant or claimant is to rely on the strength of his case. Declaratory actions fall within the exception to the rule of admission provided in the Evidence Act. In the case of Alasan and another in Ishaku, the Apex Court Perros Vival JSC now retired stated thus, I quote, Sections 20 and 21 of the Evidence Act provides for admission. Admissions in pleadings are a waiver of all controversy on the fact the pleader admits. However, the exception to this is where the plaintiff or claimant or petitioner seeks declaratory reliefs. It then becomes a different kettle of fish. The law is settled that declaratory reliefs cannot succeed even on admission by the opposite side. The reason is that declaratory action is discretionary in nature. It is a species of civil action whose purpose is to seek an equitable relief, and with the plaintiff praise the court in the exercise of its discretionary jurisdiction to promote or declare an existing state of affairs in law in his favor, as may be discernible from the averments in the statement of claim or pleadings from the claimant. Hence, the onus of proof here lies on the petitioner. They must succeed on the strength of their own case, unquote. Thus, the onus is still on the claimant to prove his case and his entitlement to the relief sought. The law is firmly settled that an employee claiming wrongful dismissal from the employment must plead and prove his employment and the terms and conditions of employment and the manner in which same was wrongly terminated. Thus, such an employee must found his or her claim on the contract of service. See the case of Briggs and Harry, Okomo, Oil Palm Limited, and Ishehe, citation captured. Ordinarily, the best way of proving an employment relation is by way of a letter of employment. However, there are instances, even in the absence of an employment letter, the court can still infer employment relationship if there are other evidence to show the existence of same. By virtue of a provision of sections 131 to 133 of the Evidence Act, he who asserts must prove. This is because the party who desires judgment to be given in his favor on the basis of existence of certain facts must prove that those facts exist. Claimant by his oral testimony in this case maintained that he was an employee of the first defendant, although he did not tender his letter of employment or any contract of employment. Is however relying on Exhibit 01, which is a photocopy of an identity card. It is a tried principle of law that documentary evidence is a hanger on which to assess oral evidence, and therefore makes oral evidence more believable and credible. The case of Emeka and Innocent and others, citation captured. Oyewusi and Olagbami, citation captured. However, such documentary evidence must be one that is proper before the court and admissible. The law is that a court has a duty to admit only admissible evidence, but where it inadvertently admits inadmissible evidence, the court must at the stage of judgment treat same as if it has never been admitted. That is, same must be expounded from its record. See the cases of Suberu and the state, Abubakar and another, and Joseph and another. By virtue of section 86, subsections 1 and its 7.1 of the Evidence Act, there are two ways by which the document can be proved, either by primary evidence or secondary evidence. Primary evidence, the document itself produced for the inspection of the court, while secondary evidence includes photocopies, certified true copies of public documents, and so on. Some circumstances in which secondary evidence as regards the existence of the document may be given includes where the original is lost or has been destroyed or cannot be found, or where the original is of such a nature that cannot be easily movable by the court, or where the original is a public document. The law is equally settled that a photocopy of a document is inadmissible in evidence without prior foundation being laid for the whereabouts of the original. I've cited some cases here which I'm skipping. The claimant in this case tenders secondary evidence of his identity card, and he has failed to supply and or tell the court where the whereabouts of the original copy, justifying the admissibility of the secondary evidence, whereas documents are ordinarily proven by primary evidence, except instances where the original is shown or appears to be in possession or power of another person, and notice to produce is given and such a person does not produce it, where the existence or condition or content of the original have been proved to be admitted by a person against whom it is proved or by his representative in interest, where the original has been destroyed or lost, where the original is not easily movable, where it is public document, as I've stated earlier. The claimant has failed to lay proper foundation and equally did not say where the original, whether the original is in possession of the defendants or not. Excuse me. It is in the light of the above stated supra that I find that Exhibit 01 is not admissible and as such is found from the record of court at this stage. In the absence of Exhibit 01, there is hardly any other document that can prove the employment relationship between claimant and the first defendant. I'm not unmindful of the fact that claimant also improved of his cases relying on Exhibit 03, which purports to be receipt of payment of his salary. A cursory look at Exhibit 03 will show that it is written in Chinese language. The law is settled that the official language of the court is English language. Hence, any exhibit tendered before the court must be in English language or interpreted in English language, even if the court understands the language. Differently put, the official language of the court in Nigeria is English language. Consequently, where a document is prepared in any other language, it ought to be translated to English language. Where it is not so translated, it will not be admissible in evidence. However, where it is admitted without objection and without its translated version, it ought to be expunged from the record of court. See the case of Faramoye and State, Abolari and Ugundele, Bello and Sander, citation provided. Thus, the court cannot engage in the translation of such documents since it cannot perform the role of a witness and a judge at the same time. In the instant case Exhibit 03, which was written in Chinese language and was not translated to English language by the claimant who is seeking to rely on same, neither was there any translated copy put in evidence. The court cannot in the circumstance be taken into account by the, the document cannot in the circumstance be taken into account by the court. In view of the above, I'm not able to find any evidence in support of the claimant case to prove that he was actually an employee of the first defendant and was paid as such or improve of his terms and condition of employment. Just a minute. I also do not lose sight of Exhibit 04, which is a letter of demand for unpaid salary, another entitlement purportedly written to the first defendant. As stated supra, a court is duly bound to act only on admissible evidence. By the doctrine of lis pendens, any document made in anticipation of litigation or during the pendency of an action is inadmissible, and if made by an interested party, CACO, AO Nigeria Limited and Umana, citation captured. The determining factor is if the maker of such document is a person interested. The disqualifying interest is a personal one, not merely interest in an official capacity. Where, however, the interest of the maker is purely official or as a servant without the direct interest of the personal nature, there are decided cases that document is not thereby excluded. The nature of disqualifying interest will depend upon the nature of duty undertaken by the servant, where from the nature of the duty, the maker can be relied upon to speak the truth and that he will not be adversely affected, thereby the document has always been admitted in evidence. See the cases of Oloma and Idigbe, citation captured. The documents that made up the said Exhibit 04 were authored by learned counsel hearing on behalf of the claimant, and which was in official capacity as a lawyer of the claimant, who is an interested party. In my view, the nature of the interest of the claimant is not different from the nature of the interest of the claimant. Sorry, the nature of the interest of the claimant counsel is not different from the nature of the interest of the claimant. The said letters were obviously written in anticipation of litigation, even going by their content. It is in the light of the above that I discountenance the said Exhibit 04. In view of the foregoing, I am of the view that claimant's action for wrongful termination must fail, having failed to prove the most basic element of the case, which is the existence of a contract and the terms of such contract relationship with the defendants. Now, let me discuss the liability of a second defendant, if any. The doctrine of privity of contract operates to the effect that only parties to a contract can sue and be sued on the contract or its breach, and no other party can incur liability under it. See the case of Vital Investment Limited and CAP PLC. Claimant in the relevant period, in this case under cross-examination by learned counsel on behalf of the second defendant, admitted that he has never had any dealing with the second defendant, and that the second defendant was not his employer or the person he was working for. He also admitted that he is only in court in respect of the first defendant, who to him was his employer, which relationship this court has stated that claimant was unable to prove, even though the affidavit in support of the notice of preliminary objection filed by the first defendant specifically stated therein that the first defendant is the contractor of the second defendant. Claimant in this case has not shown by evidence that the second defendant wronged him in any way, or that it was part of a purported and unproven employment arrangement between him and the first defendant. It is thus clear that claimant has no justification for claiming against the second defendants as he did in Relief 2. Right to an award of damage is only proven when the wrong is established. In the instant case, claimant has not shown how either the first or second defendants wronged him for them to be liable to pay damages. It is in the light of the above that I find that claimant's claim for damages must equally fail. In sum, I find that claimant has not proven his case or entitlement to any of the relief sought. Accordingly, claimant's case is dismissed. Parties are to bear their respective costs. Judgment is entered accordingly.
Your Lordship, we are grateful for the expediency in trial and the swift judgment, Your Lordship. Pray that God continue to strengthen Your Lordship. I'm grateful, sir.
Thank you. So parties are entitled to copies of the judgment. I rise.